learned that culpa in English means negligence. So when you say mea culpa, you don't simply say I am sorry, but you admit that you are negligent. So when you say mea culpa, translated in English, that is basically I am negligent. And we have learned that negligence is not cured by sorry. It is an actionable wrong. And the defense of tao lang po nagkakamali will not hold water in law. This is the essence of the study of law. This is the first and the last time that you will have this. So you have to inculcate in your minds and in your hearts the very essence of law. Because you will be needing this when you will be in the business world. And when you're in the business world, you don't regularly say sorry if you commit a misdemeanor. That is simply negligence. And you have to suffer a lot when you're in the business world for your negligent acts. The suffer or the loss may be translated to finances or financial loss. And you don't like it when you are in the business world. One wrong move, be it a case of negligence, then that is a tremendous loss in the finances. And that is not cured by sorry. So bear that in mind, all of you, especially you, AQ, because I have designated you as the leader, yes, the commander in chief. Anyway, be that as it may, we will have, according to our game plan with respect to your calendar, today we will have the last lecture, the BIDELEC, with respect to the law and contracts. Yeah? I have two topics unfinished for our legal topics vis-a-vis contracts. That is the form and the comparative table of defective contracts. If I will have time, then I will still discuss interpretation of contracts and the formation of contracts. So that will be the essence of our BIDELEC for today, ODL. Okay. And then next week will already be your Lenten season or your Lenten week, week 6. But we will still have classes online April 3. Yes. And no, that is not online. That is face to face. So everything that will not be discussed today and within the context of the wrap up will be done April 3. Yes, that will be on Monday. And then at the last portion, then I will pronounce already. If you have pronounced your CLD, I will also have mine. So that you might say that I am requiring you for a CLD when I myself do not perform. So I will also perform my CLD. And my CLD will be entitled Mi Ultimo Adios. Okay. Of course, my CLD will not be as within the context of the mechanics of your CLD mechanics, but I will try my very best to pronounce my CLD in a very emotional manner. Yes, as I bid goodbye to all of you. After that, then we still have a class February or April 4, Tuesday. But according to your calendar, I already posted the notice there that I will be absent because I will be attending a speaking engagement and my presence there is mandatory. So I will not be around. Yes. And then after the Lenten season, you come back for your exam week. But April 10 had been pronounced by Malacanang already as a regular holiday, araw ng Kagitingan. And then, according to the calendar for your schedule, April 11, we don't hold any class. That's according to the calendar. So we abide by that. And then you will have your final exam already, face to face, come April 17. Okay. So the last time that we will be facing each other face to face for the Bidalek and for the Mi Ultimo Dios will be April 3. After that, then I will see you na sa April 17 for the final exam. Okay, I will give some pointers during our last meeting. Okay, that will be April 3. So if you want, you can attend the face-to-face classes and have the pointers for the final exam. Okay, so that will be all for the announcements. No, no more. Okay, so we have to go now to the BDLEC, class BDLEC, all about the form of contracts and the comparative table of defective contracts. Ready for the recording as backup? AK? Ready po. Okay, I will now start recording. By the way, the recording will also be shared, AQ, to my FS Ked because they will be needing all the recordings with a V Module 6 extinguishments of obligations and lot of contracts for their surprise activity on Friday and Saturday, respectively. Okay, so kindly share them after our bid delect for today. Kindly post it at the AQ's messenger account. Okay, I will now start recording. Okay, we start. I will now share screen. Wait for a while as I open the video files. Okay, good afternoon again, class. This is our last BDLEC with respect to contracts. Okay. I will now share screen, the window. Okay, can you see something, AQ? Okay, then. Just chat if you have some questions, issues, and or concerns. Okay, last time we were discussing about the law on contracts, no? And we have already defined a contract according to law. We have known the elements by the mnemonics INA, essential, natural, and accidental. We have also known the stages in the life of contract by the mnemonics COPICO, the kinds of contract according to perfection by the mnemonics core or core. Then we have nominal according to name, yes, nominate and innominate. Then we have also discussed the characteristics of contracts by the mnemonics amor. Now, okay, we have ended with this particular item. We will now discuss form. When we say form of contracts, we mean how is a contract made? Okay. In Filipino, kontrata, kontrata. paano ka ginagawa. So how is a contract made? Now, that is the meaning of form. So a contract is made in any form. That's a general rule according to law. So paano ginagawa ang kontrata? Any form yan. Okay. And the mnemonics for the any form is BAUSE. Okay. So a contract, according to law, may be in writing. That's a W. Or it may be oral. Okay. Or B, by body language. Or by sign language. Or by electronic or cyber means. So erase your notion that when we say contract, yung nakasulat lang. A contract may also be in the oral form or orally made. Okay. Ang alam nyo lang na kontrata ay yung nakasulat. Pag hindi na nakasulat, ang alam nyo, hindi na kontrata yon. It is still a contract. Because under the law, an oral contract is also a contract. Now, those who cannot talk, okay, and they make use of their body language, or those who cannot talk again and hear, and they make use of sign language, that is also a form of making a contract. So that's still valid under the law. Okay, and then we have the contracts during the pandemic, perhaps, no? Or for example, and that is contract by virtue of social media, texting, electronic means, and we call it the cyber form. Okay, so there are 5 forms when we talk about a contract, and that is the general rule. Okay, so when you make a contract, then all are valid if they are in writing, be it oral, body, sign, or electronic mode. They are all what we call valid and enforceable. However, under the law, there is what we call exception to the general rule. When we say exception to the general rule, there is one form only prescribed by law. And that law that prescribes that particular form is what we call the statute of frauds. Statute of frauds, statute means law. You have learned the word fraud, and we mention it as deceit. Okay. However, when you have the word fraud with an S, then it does not follow that it is many fraud. It has changed its meaning when we have fraud with an S, frauds. So when we say statute of frauds, we simply mean the law on prescribed form for contract. Okay, so I repeat, under the law, there are many forms of contract by the mnemonics BAUSI. However, under the law also, there is one, okay, form that is prescribed, and that is what we call in writing. So out of the 5 forms, there is one under the exception, and we call it in writing or in written form. That is in compliance with the statute of frauds or the law on form. Okay. So what law is that? The statute of fraud. It is also part and parcel of Republic Act 386. Okay, as you can see with the legal basis. Okay. Now, when we say that a contract is in writing, they are also of 2 forms. So when in writing, there are 2 forms, either private writing, private document, or there is a legal purpose for private memorandum. Now, what you know about a memorandum is what we call a warning, okay, to all. Like when you say a memo coming from the dean, that memo is what you know as a warning. But in legal parlance, memorandum does not mean warning. Memorandum simply means it is a form or a contract that is in writing. Okay. So the in writing here will be part and parcel of a contract if it is translated into written form. So we have what we call private writing. Now, according to the law, okay, private writing means it is not a writing or a document or a memorandum that is done in private or confidential. That is not the meaning of private writing. Private writing is, under the law, there is a written document or a document or a memorandum that is in writing, but that is not notarized. Like, for instance, you make a love letter, you make an excuse letter to me, okay, and you make a love letter to your boyfriend or girlfriend. Is that a contract? Yes, that is a contract. Is it in writing? Yes, because it translates to letters, words, sentences, paragraphs, etc. But is that private? Yes. Why is it private? Because it is only me and you? No, that is not the meaning of private. It is private because it has not been notarized. What do we mean by notarized? When we say notarized, there is a person authorized by law to transform the private writing into a public writing or document. That's why you always hear the word notary public. Now, let's have to define some legal terms. So notarization is the act of converting a private writing, a private document, or a private memorandum into a public document, or a public writing, or a public memorandum. So when we say public document, we do not mean that the public knows. That is not the meaning of public document. We say that a document is public when it is notarized by a notary public. There's again an interference. If I will be pissed off by another interference, then I will leave this BBB. Who is that again? I cannot hear audio. You cannot be disciplined, really. I'm painstakingly having the burden of not having your audio. Now here comes an interference. Oh my God. One more interference. I tell you, I will leave you this afternoon. And I will never give you a lecture again. Try me. I warned you already about these interferences, that they constitute breach of Canvas rules, and yet you do not, or you ignore everything. You want a case here at UC? You want? I'll give you a case so that you will learn your hard lesson. God. And I have the evidence because it is being recorded. You're pissing me off. You have already pronounced during your CLD that I am a strict disciplinarian. Yes, I admit that ever since. I'm a strict disciplinarian because Filipinos, especially your generation, do not accept discipline. Much more, you are undisciplined. If I will tolerate that kind of attitude, then I will be confused in the lecture series, especially in the ODL modality. That's why I set rules within the context of law or within the bounds of law so that you will realize the effects of your actions. You see, you are the worst generation that I handled. with respect to attitude and discipline, because you are pandemic babies. You think that the social media is your boss. You think that the social media is your world. And you cannot accept that there is an actual world that you have to reckon and abide. That's why we already have the face-to-face, so that you will realize that the world you are in during the pandemic is not the actual world. The actual world is the physical world, not the world that you know. And in the world that you know, your social media, you can control everything. You can command. But in the actual world, you cannot. That's why you refuse to follow, because what you know is a world that you can control with your own hands. Now, here comes an actual world that you cannot control. There are many authorities that you must abide, and there are many protocols that you must follow. Now, if you don't like these protocols and you don't like these authorities, then contain yourself with your world and never get out of it. You must be disciplined, because the real world must be within you. One more, I'm warning, one more interference, I will leave this ODL. Okay. Can you see something, AQ? Okay, then. We continue. Now, who is this animal called a notary public? In the Philippines, a notary public is a person authorized by law to make notarization or to convert a private document into a public document. Now, in the Philippines, all notaries public are lawyers. So lawyers like me, okay, including juris doctors, are notaries public in the Philippines. But it does not follow that all lawyers perform the notarial act. I repeat, okay. All notaries public in the Philippines are lawyers, but not all lawyers are notaries public. What does that mean? Because not necessarily and automatically that when you are a lawyer, you are also a notary public. No, you have to apply for a commission, and the commission must be approved by a court and that of the Supreme Court, and you must exercise such commission within 2 years from the grant of commission. Like me, I am a lawyer, I am a Juris Doctor, but this year I am not a notary public. Why? Because I did not apply for a commission for 2 years. So does that mean to say that I cannot convert a private document into a public document by virtue of notarization? Answer, yes, I cannot. There, that's the meaning of that. So I don't have the authority this year and for the next 2 years to convert any private document into public document. That's why, for instance, uh, you lost something, then you have to execute an affidavit of loss. Then you go to a lawyer, and the lawyer must be a notary public so that he will notarize your affidavit of loss, and the affidavit becomes a public document. If the affidavit of loss is not notarized by a notary public, then the affidavit of loss is simply a private writing. I repeat, if an affidavit of loss or any affidavit for that matter is not notarized by a notary public, then that writing or document is simply private. But if that affidavit of loss or any affidavit or contract for that matter has been notarized by a notary public, then the document becomes public. But it does not follow that when the document becomes public and notarized by a notary public, that the contract is valid already. Like for instance, two persons enter into a contract wherein the object is marijuana or shabu, sale of shabu. Is that valid? No. Suppose they executed a written document, a private contract, and then the sale of said particular shabu, and they had a notary public notarize the same. Will the notarization invalidate the invalid or void contract? The answer, no. Okay, that is the meaning of that. So it does not follow that when the private writing is converted into public document by virtue of notarization, then it also validates the contract, which is void. No, it does not follow. Okay. Now, according to law, there are acts or rights or contracts that must be notarized, meaning public document. If they are not translated to public documents, then the validity is at stake, meaning you cannot enforce the contract. Why? Because you did not comply with the statute of frauds that the contract must be in writing. What are these? Okay. If there is a cancellation, cession, okay, or a transfer of rights and transfer of actions, okay, any kind of transfer or cession of rights and action, it must be in a public document, meaning it must be in writing and notarized. Otherwise, you cannot enforce the same. So if it is not notarized, then it remains to be a private writing, meaning it is only between you and the person who signed the particular contract. Now, there are also powers that are granted by virtue of contract. We call it the general power of attorney and a special power of attorney. Perhaps you have heard this SPA. An SPA is a document. It is in writing because it complies with the statute of frauds. And that SPA must be notarized, meaning it must be converted into a public document. If the SPA or special power of attorney has not been notarized, then that SPA is simply a private one that cannot be enforced to the whole wild world and cannot be admitted as evidence in court. That is the meaning of that. If you will also sell real properties like land, buildings, house and lot, like that, it has always to be in a private or in a public document because that is compliance with the statute of frauds. Suppose you do not like to comply with the statute of frauds, well, the effect is you will suffer the consequences. If the law or the law prescribes a particular form and you do not follow, do not cry 1,000 rivers if that contract of yours will not be enforced. Simply because you did not comply with the law. That is the essence of a law. So you cannot have things the way you like it with respect to contract. You must abide with what is prescribed by law with respect to your document or to your contract. You have to follow the law. Okay. Another one is if you are an heir or successor, okay, tagapagmana, lahat ng mamanain mo dapat nakasulat. Otherwise, it is so hard to implement. Yes, that is the meaning of that. So, kung may mamanain ka sa parents mo, sabihin mo sa parents mo, okay, isulat nila lahat ng mana mo. Otherwise, you do not comply with the statute of frauds, mahihirapan tayo to trace which one will be yours. If that will be the case, then we apply intestate succession. So, iba na naman kasi yun. Nakakalito na naman yon yung intestate succession. So, mas maganda, if you have some rights, you have some acts, you have some powers, and you are an heir, then everything must be translated into writing. Isulat. Yan. Kahit ang kontrata that has what we call money involved, monetary contracts exceeding or 500 or more. Basta 500 or more, you have to reduce the contract into writing. Pero pag below 500, kahit hindi mo na isulat. Bakit? Because that is the essence of the law. That is what the law prescribes. Then you might say, I would like it to be in writing. Fine. Even though it is 1 peso, fine. But the question is, if it is in writing and you have to go to the notary public, how much will it cost you to have that private writing into a public document? See, like for instance, you ride on a public utility jeepney, you pay your 12 pesos. Do you still have to go to a notary public or to write that document or to reduce it into writing and let the driver and you sign, and then you say, you wait for a while, I'll go to a notary public for the conversion of the same to public document? No need, because that particular contract of transportation or contract of carriage is what we call within the context of oral contract. You don't need to write it. But is it still a contract? Yes. When you buy at the wagwag, actually, that is with a written form, especially if it exceeds 500 pesos. But the question is, in practice, we do not do that at the wagwag. Okay. If you have given the money and then they have given you the goods, then that's it. The contract of sale is done. Okay. But for any contract respecting money or monetary contract, especially exceeding 500 pesos, then you reduce it into writing. Any kind of writing will do, whether you write it in your, on a piece of paper, on a scratch note, uh, on an eco bag for that matter, or even at your clothes, then that is fine. That is within the context of private writing. Yes. Now, once the notarization will come in, then the private writing becomes a public document. I hope that some of you already have working knowledge with this, that there is a document and you go to a notary public for the notarization, and the essence of that is the private writing becomes a public document. So when it is a public document, you can enforce that with any people, with any things, or it can be admissible in court as evidence. That is the meaning of private and public document. Okay. Now we have also what we call the electronic mode or the cider mode. That is also a law. So aside from the statute of frauds that it must be in writing, when the in writing was done electronically, virtually, or by the cyber mode, then you are complying actually with the Public Act 8792. By the way, when you execute a contract of sale, the best evidence that you have a contract of sale is the receipt. So always ask for a receipt. Now, the receipt is of two kinds, the official receipt and unofficial receipt. Okay. Official receipt is a receipt that is in compliance by the Bureau of Internal Revenue. An unofficial receipt is any writing, be it one-fourth sheet of paper, what do you call this? Any writing that will say that the amount and the signature of the both of you will be called an unofficial receipt. Now, is an unofficial receipt admissible in evidence? Yes, because that is a private document. If you want, okay, that it will be admissible as evidence in court with respect to payment, then you let a notary public notarize that sheet of paper. Is that allowed? Yes. Is that allowed? Because what you know only is that an affidavit is a writing that is made by a lawyer. No, any writing that is that will undergo the process of notarization will become public document. Even your what we call love letter, you want it to be public document, then you go to a lawyer or to a notary public and had it notarized, then it is converted to a public document that is already admissible as evidence. That is the meaning of that. Okay. So the question now with electronic or cyber mode is it is very hard to prove. Why? Because it is done in the social media. And in the social media, there's what we call social magic. Social media magic, meaning you can alter the substance. So, but is it admissible in evidence? Like for instance, okay, uh, there is a text and you complied with the requirements of a contract of sale. You ordered, and then here comes you the delivery. You were scammed. Then you want to have file a complaint. Then your evidence will be your text messages. Will that be a fine in court? Yes, it can be. However, okay, according to the E-commerce Act of 2000, you have to prove with some requirements that the electronic document or the electronic writing is unaltered and authenticate. That is the meaning of that. Yes, like for instance, text messages, fax, email, messages, FB, RG, Twitter, messages. They can be used as evidence in court, but you have to comply with certain rules. And these rules are pronounced in what we call the rules on evidence or the rules of court. The very basic premise is the document or the writing at the social media or in the electronic mode must not be unaltered. How will you prove it? Well, by virtue of what we call testimonial evidence and documentary evidence that you have to present in open court. That indeed that document is authentic and genuine and it has not been amended or changed. Because we have the tendency that we change the tenor or the words in the electronic mode. And then we say, oh, that is not the way that it was said before. Oh, see, it is very susceptible to change and amendment. And that is not allowed in court. Yes. So that is the essence of electronic or cyber mode of what we call in writing. It's very hard to prove that it is unadulterated or authentic for that matter. Okay, that is what we call the form. So I repeat with respect to form, the general rule any form. The exception is there is a law that requires a document to be in written form, and that law is the statute of frauds or the law on form. Now, with respect to the law on form, there are two kinds of documents or in writing. We have the private and the public. Private is anything without any document without notarization. But once a document is notarized, then it is converted into public document. There are some rights or acts or powers, okay, that are within the context of law, within the context of the statute of frauds that must be in writing and it must be notarized or in a public document. With respect to electronic mode, yes, they can be had. They are also valid form. They can also be admissible as evidence, but there must be compliance with the rules on evidence. And then its admissibility. Okay, that is with respect to form of contract. Any questions? Okay, next. Okay. We now go to the comparative table of defective contracts. To make our lecture series very facilitated with respect to defective contract, then I have prepared a table. Okay. So as you can see in the table, there is the first column, the item or the particular, and for the next four columns, we have the four defective contracts. Under the law, under the Public Act 386, there are four defective contracts, meaning there's something wrong with this kind of contracts. That's why they are called flawed or defective contracts. And they are void, unenforceable, resistable, and voidable. As you can see with their sequence, this is the most defective. Void is the most defective, followed by unenforceable, then resistable, and the least effective is voidable. Okay, we will learn more of them as we compare one from the other vis-a-vis this comparative table. I repeat, there are four defective contracts. The mnemonics is verb, V-U-R-V, namely void, unenforceable, resistable, voidable. Now, let's try to dissect each of these defective contracts anent or vis-a-vis this particular item. Defect. Ah, when we say defect, where lies the flaw, the imperfection? Okay. In a void contract, the imperfection is lack of essential elements. I told you last time that about this cup or the essential elements, namely cup, consent, object, and consideration. Now, in the absence of one of the cup, then the contract becomes void. That is the essence according to law. With respect to unenforceable, okay, the defect or the flaw lies in the lack of form. There. That's why I discussed first the law and form. Now, it may seem here lack meaning, okay, it does not comply with the statute of frauds, or there is lack or authority or capacity of the contracting parties, like when one is minor. Okay. So the contract is now translated to be a defective one, but unenforceable. There's also a contract that is resistable in nature. Where lies the defect? The defect is caused by a lesion or lesion. What is lesion or lesion? It is injury or damage. So if the contract causes injury or damage to one of the contracting party, then that contract falls under the category of a resistable contract. Now, with respect to voidable contracts, the defect lies only in the consent. I have already discussed the vices of consent. So if a contract has a defect in the consent, and our mnemonics for the vices of consent is fun, vim, fraud, undue influence, violence, intimidation, and mistake, and I have discussed this, then the contract will fall under the category of voidable. Okay, you will learn more as we go along. Okay, now, suppose a contract is defective. So, does that mean to say that it is illegal? Okay, let's have the second item, legal effect. What is the effect in legal parlance of a void contract? None. What does that mean? If there is no effect legally for a void contract, meaning as if there is no contract. Why? Because I told you last time that in the absence of one of the three essential elements, then there is no contract to talk about. Okay. Now let's go to unenforceable. This is what I'm telling you now. Is the contract valid? Yes. However, the legal effect is it cannot be enforced by court action. Meaning, if you go to court to enforce that contract with lack of form, then there is no evidence to prove that there is a contract because you did not put it into writing. Like, for instance, you executed a contract with another person, you borrowed money, but there is no evidence. You did not write it, and it is worth 10,000 pesos. When you try to get the money from the borrower will say, I did not borrow from you, for Christ's sake. I don't even know you. And then you say, oh, come on. You borrowed to me. Then the person who borrowed will say, what's your evidence that I borrowed 10,000 from you? Eh, now you are dumbfounded. Hindi ka na makapagsalita kasi wala kayong kontrata. Sabi ng batas, you have to translate it into writing. You did not. So what is now your evidence? And then you will say, oh, yeah, you will now fight with her, but you don't have evidence. And then you say, I will sue you. When you go to a lawyer, and the lawyer will ask you, is it true that this particular person borrowed 10,000 from you? Yes. Oh, what's your evidence? You cannot say anything because there is no written form. That is now the meaning. So who will now prove that indeed that there is what we call borrowing? So you have to go now to electronic means. Perhaps there are some writing that will signify in texting that indeed there is borrowing. Or you have to produce the testimonies of witnesses that had witnessed that indeed there had been borrowing of money. So you see, it's very hard now to prove the legality of your contract. Why? Because you did not deduce it into writing, lack of form. So your contract is valid but unenforceable, meaning you cannot go to court to enforce. So the judge will say, how will I do it? How can I let her, the borrower, pay when you don't have any evidence that she borrowed money from you? See? So that is now the effect. It's so hard to prove now. Okay. Now, with respect to rescissible contract, there is damage. So if there is damage, we have learned that there is injury, then there must be a return or what we call translation of the damage to damages or monetary consideration. So for the meantime, that there is no what we call a return or translation of the damages or the damage into damages, then the same contract is valid and enforceable. But it can be canceled by a competent court. So you cannot just cancel a rescissible contract by yourself. It has to undergo a court process. But for the meantime, that it is not canceled or rescinded, the word is rescinded by a competent court, then it is valid and enforceable. Now, we will have example by and by. Now, with respect to voidable contract, this is also valid and enforceable until annulled by a competent court. Like the CLD yesterday about Mr. Floresca, no? About the marriage, quote unquote, that transpired between him and AQ Dayak. And afterwards, it was discovered that AQ Dayak is a transgender. Okay, so is the marriage between Floresca and AQ Dayak a transgender? According to the story of Floresca, valid? Yes. But it can be annulled on the ground of their homosexuality or fraud. But he has to do it within 4 years. He has to go to court to uh, erase or to annul the valid and enforceable contract. Why? Because the contract, the marriage contract, is voidable. Okay, meaning there is what we call bias of consent or what we call fraud. Yeah, there is a commission of fraud. So that will be the ground. Will the court admit such ground? Yes, and that is annullable because the contract is voidable. That is the meaning of legal effect vis-a-vis the four defective contract. Let's go to another item. We have what we call the kinds. Okay, these are now the kinds of time check. It's 421. These are now the kinds of defective contracts. When we say kinds, okay, we have to enumerate them. All of these come from law. With respect to void contracts, there are 7 kinds. With respect to unenforceable, there are 3. For resistable, there are 5. And for voidable, there are 2. All of them are prescribed by law. I simply summarize them. Now, simulated contract. There. Simulated contract, as the name suggests, is a fake contract. Like, for instance, the marriage contract executed by the stars, by the artists in one telenovela, assuming Arguendo in one film. Okay, the two got married. Sofia Pablo and Alan Ansad got married. Is that really a marriage? No, that is simply a simulated contract of marriage. So is that a void contract without any effect? Yes, because it is only done with respect to cinematic purposes. Sa pelikula lang. That is the meaning of that. Okay. If the object also is contrary to law, that is void. I told you a while back already with respect to the object called shabu. If two persons entered into a contract, buyer and seller, but their object is shabu or any object that is contrary to law, then that is what we call a void contract. Like in the social media, there is a news that a parent or a mother sold her daughter or her baby, okay, for consideration for 5,000 pesos. They even executed a written document for the sale. Is that valid? No, that is void. Why? Because the object is contrary to law. Now, suppose the contract that had been reduced into writing passed through notarization, then that will not cure the defect. Why? Because a void contract has no legal effect. So if it is notarized, then it remains to be void. And the lawyer who notarized the void contract can be charged with gross ignorance of the law and tantamount to what we call his or her suspension or revocation of his license as a lawyer. Katangahan yun. Okay. But there are some lawyers who do not read the contract. They simply notarize and notarize and notarize. They sign because of the fee. Yeah. That is the essence of being a lawyer and a notary public. You have to read the document that you are notarizing or signing, because it may happen that there are some terms and conditions there that are within the context of contrary to law. So if that will be the case, then you have to advise the client that can never be. I cannot notarize this. And then you say to the client that this is void, meaning it does not have any effect. Whether you will go to court or not, this is of no moment. That is the meaning of that. Now, with respect also to cost, we have learned the 3 kinds of costs: remuneratory, onerous, and pure beneficence. If there is no existing cost to a contract, which I doubt, all contracts have with a cost, because if there is no contract or there is no cost, then that is what we call lack of essential elements. That is automatically void. Okay, so that is the meaning of that. So when you enter into a contract, you always ask yourself, why is it that I am signing this document? Like when you entered into a contract with UC, why is it that you are paying tuition? Why is it that the tuition is high? Why is it that my course is 21? You have to ask, because that is the cost. If you can answer that convincingly, then you affix your signature. If you cannot answer that convincingly, those questions, then do not sign, then do not have a contract with UC. As easy as that. But what is happening is when you enroll, you do not read. You simply affix your signature. You don't know what is happening to you when you are enrolled. That is what we call a contract of adhesion. If you do not read all the terms and conditions and then you affix your signature, then you are caught off guard. You cannot say after some time that you were fooled by UC. See, That is the meaning of the. So the next time that you enter into a contract, simple or complex contract for that matter, read, because that is the essence of being a college graduate. You should know how to read contracts. Now you know why is it that back 104 is in college and not in high school and elementary? Because in elementary and high school, especially elementary, you don't even know how to read. So you must train yourself first to read. So you must know English so that you can understand. Now, when you are in high school, you have some, some subjects about English so that you can comprehend English. Now that you are in college, you have to read. What are you reading? The law. You have to comprehend them. Otherwise, you die. You might be laughing like in your CLD yesterday when Aki Dayag tried to mimic me about these words, you die a natural death. You will remember me when you're in the business world and you do not know how to read and comprehend the law. You will really die and you will suffer everything. And you cannot say, oh my, I was not able to read. And then they will say to you, Tanga, you're a fool. You're a dumb. You're a college graduate and you do not know how to read contracts. What will be your defense? You're a college graduate. You have your evidence of graduation and you cannot comprehend contracts. Oh my. You will really die. And they will say, where did you graduate? And then you will say, UC? Oh, come on. You're ashamed to UC. And then they will ask you, who had been your teacher in law? And you will say, Attorney Kalonghe or Sergi. And they will discover that I'm a Juris Doctor. So, will I have a face with them? See, that is the meaning of your stupidity, quote unquote. So you have to imbibe law in your life that you are now in your college life, especially when you will be in the business world and become a professional. Because if you don't know this stuff, then you will really die. Meaning you will suffer all the losses. Whereas you cannot even have an employment. Or if you have employment and you don't know how to read contracts, what happens is you're fired. And when you are fired, do you have any remuneration or salary? None. So if you don't have remuneration or salary, will you survive this world? No, I don't think so. So it is a chain of events. That's why Back 104 had been introduced to your life. And this will never come again. Okay? If the intention is not also certain, then it becomes void because it is part and parcel of the cause. Now, I told you last time my lecture about this outside the commerce of man. So, translating now to these two restaurants at Burnham Park, they are outside the commerce of man. Then, that contract of lease of these two must be void because that is the essence of the law. But how come they have been there since time immemorial? I think they are already there for 40 years. And the city government of Baguio is making good money out of it when it is a void contract. That I cannot answer. But the law is very clear. Burnham Park is a national park. It is outside the commerce of man. Okay. Until there, only that I can discuss because I don't like to be a rebel to the city government of Baguio. Now, impossible service, like if they will get you for a travel going to Jupiter and you exceeded because of your stupidity. You know it already that a travel to Jupiter is impossible at this point, at this time. But you exceeded, you even signed a contract and you gave money. Now, can you enforce that contract? And can you charge the person in court? No, actually, because that is void. So the effect is as if there is no contract. So if you enter into that kind of contract, then that is stupidity. And then you will say you're a college graduate. See, it is better if you are only an elementary graduate and you are fooled. Your defense is ignorance, okay, or lack of knowledge. But when you are a college graduate, you cannot have the defense of ignorance or lack of knowledge. Bear that in mind. Okay. Now, there are also contracts that are declared void by virtue of Executive Order 209. Like, for instance, marriage between first cousins under Executive Order 209 is void. You are not allowed to marry your first cousin, even though you love him or her very much. Okay. Marriage between minors is void. When we say minors below 18, even though the consent of the parents had been considered, even the parents signed the marriage for these two minors, the marriage of the minors is null and void. Why? Because the law declares it to be void. You cannot do anything. Okay, there. Now, for instance, marriage between second cousins under Executive Order 209 is valid, meaning it is allowed that you marry your second cousin. Then you may say, ha, is that the case? Yes, you read Executive Order 209. First cousins, not valid, void. Second cousins, valid. However, according to medicine or in the medical world, if you marry your second cousin, there is a tendency that your offspring will have defects. So the defect will not lie in the contract, but the defect will result to your offspring, meaning you will have abnormal children. That is according to medical world, to the medical world. I do not know if that is true or not because I am not a medical doctor. I am a jurist doctor. But what I know is marriage between second cousins is valid under the law. Marriage between first cousins is void ab initio or null and void under the law. And what law is that? Executive Order 209. Okay. Now we go also to unenforceable. This now unauthorized contract. Like for instance, okay, you are the boss, and then you have a secretary. Then here comes a client, and then the secretary, without authority from you as the boss, entered to a contract with your client. Is that contract between the secretary and the client without the authority of the boss valid? Ah, the answer is the contract is defective. It is unenforceable. Why? Because it is an unauthorized contract. So if it is an unauthorized contract, will there be a cure? Let's see by and by. Okay. Now, statute of frauds. If you do not comply with the statute of frauds, when the statute of frauds say it must be in writing, the contract must be in writing. You did not have it into writing, so there is no evidence. So the contract becomes unenforceable. So what happened? So you cannot have an evidence in court. So how can you enforce the same? This is very tedious now and laborious to look for witnesses that will prove that indeed there is a contract between you and the other party. This one, I'm telling you, with respect to this one, is different from this one because here the incapacity is both. Okay, like minors marriage will fall under here, void. It will not fall under here. Although both parties to the marriage are incapacitated because of minority, okay, the marriage is a contract that will fall here. It is void. Now, we are talking here if the two parties of contract are minor. Like, for instance, there is a sale of land. Okay, a minor sold a piece of land to another minor. Is that valid? Okay, the answer is the contract is defective. Why? Because both parties are incapable or incapacitated to give consent. So what? Suppose they reduce it into writing. Okay, that is not the question. So is there what we call a defect still in the contract? Yes, the defect is still unenforceable. Meaning, the buyer cannot enter the land because it cannot be enforced. Suppose he already paid. Okay, what happens to the payment? That is now the issue. So, because of these issues, they have to go to court. So they have to prove by evidence that indeed they have a contract. Now, if it is proven that they are both incapacitated, then the law will come in. Then the contract becomes unenforceable. Okay, so is there a remedy? There is a remedy. What is the remedy? I will not tell the remedy. Why will not I tell the remedy? Because that is what we call remedial law. If you will be a victim of this, then that's the time I will remedy your cause if you hire me as your lawyer. Yeah, because that is already part of remedial law. When we say it's part of remedial law, it's part of defense. Okay, I cannot tell you the defense because that is my secret weapon. You have to be my client first. And you have to encounter the unenforceability of your contract so that I can come in and set the defense, especially when we go to court. Yeah. So for the meantime, the lecture says will cover only the kinds. Okay. As to the remedy, more or less, that will be part of what we call the lawyer-client relationship. Okay, now we go to rescissible contract. We said that rescissible contracts are valid. They are also they are also enforceable, but they can be rescinded or canceled. But it can also be a court, a competent court who can cancel. Like I'll give you some examples. Guardians. Guardians are what we call persons who take care of another person. This is not a security guard. You know, when we say guardian in contemplation of a law, we mean a person who is taking care of another person. That other person being cared of by the guardian is called the ward. We say ward when we talk of persons under the custody of another person. Like for instance, you, okay, you are minor, you are a ward. You are being taken care of by your guardian or your parents. Another one, suppose you are away from your parents, okay, and then here comes your uncle, okay, you are in the custody of your uncle, you are living with your uncle or with your aunt. Then your aunt will qualify as a guardian, and you as a minor is a ward. Now, suppose during your stay with your uncle and you are a minor and you have some properties, and these properties of yours, okay, had been sold by the guardian. Okay. Is the sale between the guardian and the client or the buyer without your consent because you are minor? Will that be valid? Yes, under rescissible contract. Will it be enforceable? Yes. Okay. But suppose you do not like the sale because you said you do not know yet the repercussion and effect of the sale because you were below 18. But when you reach 18, you were able to talk to a lawyer. You were able to have what we call a lecture with me, Sir G, that you are alleging yesterday during your CLD. Okay, that you learned something during your stay with me. Now you have learned that there is a lesion, there is a damage. You have been damaged by the sale. Like for instance, the sale is the price of the land is 1 million, and there is what we call a lesion or a damage that happened within the context of the law. Yes, you have to see the percentage of the damage. And then you will say, I am already 18. I do not like the sale. I want the sale to be canceled or rescinded. Is that possible? Yes. Yeah. That is the meaning of rescissible. But if you do not talk and you do not go to court, then the resistable contract is still valid and enforceable. You cannot complain, yeah, that it is defective because you did not do anything to cancel or rescind the contract. Now, you cannot also say to your uncle or to your aunt, the contract is resistable. I have learned that with Sir G. You cannot just say that. I will rescind it. I will rescind it. You cannot rescind it. It must be the court who must rescind it. So you have to get a lawyer again. So as you can see, when you are in the business world already, one day in your life as an entrepreneur or a businessman or a professional, you will need the services of a lawyer. That is guaranteed because you might be a victim or you might be the perpetrator or the accused or the felon. Okay, there. That's the meaning of that. Uh, if there is fraud, again, here again, if there is fraud, then what we call, if you, like for instance, fraud of creditors, okay, you entered into a contract, okay, you borrowed money again, okay, and then you run away, okay, so that's in fraud of creditors. Is the contract that you entered into, borrowing money, valid? Yes. Is it enforceable? Yes, but the question is you run away and you don't like to pay, okay, so the creditor will not go to court and they will arrest that the contract is rescissible. Why? Because of this ground, in fraud of creditors. You went away with your property. So they will now get the property and via the court action, it will be applied to your debt. Okay. Litis pendentia, on the other hand, these are things under litigation. So when the things are under litigation, you cannot settle the same. Suppose there had been a sale. Okay, so that is still valid and enforceable. But you have to have the action to rescind the sale while on the ground of litis pendentia. Okay, and other grounds declared by law as rescissible. That is within the context of GAF law. Time check. Are you still there, AQ? 4:43. Okay, there. Okay, there. That's the meaning. Now, with respect to voidable, okay, we have what we call the V. Okay, two only kinds. The vitiated consent. That's what I'm telling you before, no? The fun vim. Fraud, undue influence, violence, intimidation, and mistake. That is the meaning of vitiated, meaning defect in the consent. Okay. I have explained that already, no? Like for instance, gunshot wedding. You said yes. Is that valid? Yes. Is your wedding valid? The marriage is valid because you said yes. Yes, I do. But it is gunshot, meaning at the point of the gun. Okay. So you have to go to court so that the valid enforcer you do not like. So you have to go to court for the annulment. Annulment and decision is one and the same. In common parlance, we call it, or layman's term, it is cancellation. But the word is different when we are talking in legal parlance. If we talk of rescissible, then the exact or legal term that must be used is rescinded. But in layman's term, it's still the same, cancellation. In voidable, the proper term to be used is annulment or annul. Okay, but in layman's term, the meaning of annul, plain and simple, is cancellation. So can you cancel a marriage? Yes, we have already discussed this on the ground of fraud, like homosexuality, sexually transmitted diseases. But you have to do it only within a particular time. We call it the prescriptive period. Now, here again, look at this one and both. If both parties are incapacitated, then you apply the rules and then unenforceable. But if only one party is incapacitated to give consent, then you apply voidable contract. Like for instance, okay, marriage again. One is adult already, below above 18. Okay, but the other one is not. Okay, so what happens with that? Will it fall under the category of the void? Okay, yes. Here, because it is declared by law as void. So what is this now? Okay, with respect to other contracts aside from contract of marriage. Like for instance, you enter into a contract, you are already an adult, and then you enter to a contract of sale with a cell phone. You are selling a cell phone, you are already adult, and you are selling it to a minor. Okay, is that valid? Yes. Is it enforceable? Yes. So can you get the uh, the money? Yes. But that minor, after some time, can go to court for the cancellation on the ground of incapacity. Can he do that? Yes. So be very careful when you are negotiating or having a contract with a minor, because if one party is incapable or incapacitated to give consent, the contract actually is defective. It is voidable. But for the meantime that you are not going to court or anyone is going to court to complain, then it is valid and enforceable. So be very careful. You have to know this, that when you are transacting with a business, okay, you are entering into a contract, then both of you are capacitated. What is the meaning of capacitated? Both of you are of legal age. And what is the legal age in the Philippines? 18 and above. If you are below 18, even though it is 17 years old and you are 1 second away from your birthday to become 18, are you still considered minor? Yes. You cannot round off? Yes, you cannot round off. So that will be a defense. No? Okay. So be sure that when you go to a bar and you drink, you are of legal age. So when they do not give you a drink, do not say, it is my right, I can pay. But if you are below 18, then they will not give you intoxicating liquor. And then do not complain. And or you might say, oh, tomorrow or at the strike of 12 midnight, I will already be 18. If I am the owner of the bar, then I will say, we wait for the 12 midnight. At the strike of 12 midnight, you're already 18, then I will give you all the drinks that you like. The same with cigarettes, no? That's why we have the ordinances or the laws, no? The local laws about non-selling to minors. Why? Because actually that is voidable. But of course, no one will go to to court for the annulment of the same. Yes, of course, because that will be tedious and laborious and very costly. The complainant will have to hire a lawyer, and you will also have to hire a lawyer for your defense. So we will be very happy. We will hire us. We will have money again. And the case is very simple, correct? See? So be very careful. You have to know this. Yes, not by heart, but you should have a working knowledge with this because it may guide you, okay, or it will really guide you when you are already in the business world. Time check, it's 4:49. Now we go to action. Suppose there is a defect in the contract. What shall you do? Okay. So basically, when you say action, this is a case in court. So basically, defective contracts are cued by court cases. You have to go to court. You cannot just do it all alone. Okay. So what do you do when there is a void contract? There must be an action for declaration of nullity. And that is imprescriptible. We have learned prescription. When we say imprescriptible, even though there are many years already has passed, then you can still go to court for the declaration of nullity. You don't cancel a void contract. You nullify a void contract. And that is what we call an action for declaration of nullity. Like you married your first cousin that is void. Can you say to your first cousin, I have discovered that you are my first cousin. Let's separate. Because according to law, according to Executive Order 209, and Sergey said that our marriage is void. So we now separate and go on our way. I will now look for another one, and you will look for another one. Can you do that? No. That is now the effect of a void contract. You have to go to court to declare it that your marriage is nullified or nullity. It is void. You cannot do it on your own. You have to go to court. So you see, all of your actions when you're in the business world or in your professional life, then be very careful, because one wrong move, you need my services or the services of a lawyer. And I will love that because you will be paying me much. Now, if you cannot pay much, then you better go to the PAO, to the public attorney's office. That's the meaning of that. Okay. Mm. Now, when we take an enforceable contract, this is what I'm telling you. So if it cannot be enforced, you go to court. That is what we call action for recovery. If there is already total or partial performance. Now, prescription not applicable. What do we mean? Then we do not count the years. So even though there are many years has passed, then you can still go for the recovery. That is the meaning of that. But you cannot go to court for an action for recovery if you don't have a lawyer. So you see, you need again a lawyer. Now, with respect to rescissionable contract, then you can file an action for rescission or action for cancellation. But this can only be done within 4 years. After 4 years and you do not go to court, then the rescissionable contract remains to be valid and enforceable. You cannot do anything on that. You cannot complain because you are barred by prescription. The same with what we call voidable contract. You only have 4 years from the discovery of fraud, like in marriage, that you have to go to court for filing of an action for annulment. Otherwise, your action will prescribe, or your right for the annulment will prescribe in 4 years. And you cannot do anything already. It remains to be valid and enforceable. So that will be the repercussion for defective contract. So be very careful when you enter into a contract. Be sure that the contract will not fall under the four defective contract. Because if the contract that you will enter into will fall under these four defective contracts, then you have to go to court for the remedy. And when you go to court, you need the services of a lawyer. You cannot just go to court and say, "Hey, Your Honor, I'm filing a declaration of nullity." And the court will say, "Who are you?" It is short of say, "Get the services of a lawyer," because only lawyers will talk in open court. You cannot talk in open court and state your case. Okay? Now, when your contract is defective, is there a cure? Oh, di na. Is there an act to validate the act? Oh, yes. Okay. Yan na, no? And is there a cure? We're not going now. Now, with respect to the rectification, is there any act that can be done so that the void contract will become valid? Answer, none for a void contract. Is there an act that can be done so that an unenforceable contract can become enforceable? There is, can be, there is. Yeah, that's what I'm telling you. Is there a remedy now for an unenforceable contract? There is, but I will not tell you the remedy or the ratification or the validating process, because you have to experience first the defective contract so that you will become my client. Now, is there an act to validate a rescissionable contract? No need. Okay, all you have to do is to go to court because that is valid, but it can be cancelled. So you have to go to court. Okay. Is there an act to validate avoidable contract? There is. There is also an act to validate avoidable. So avoidable becoming valid. Can that be? Yes, that's possible. How? I will not also say it because that is part of remedial law. You have to experience avoidable contract so that we can, what we call, apply the ratification process. I'll just give you one uh, example. Suppose that's according to Mr. Floresca's CLD yesterday, no? Hmm. The discovery of the transgender for Dayak was done during the honeymoon. Okay. then that's possible for annulment. Suppose the discovery of the being ecudaic as transgender was before the honeymoon, but after the marriage ceremony. Okay, it was discovered perhaps by word of mouth that indeed that ecudaic is transgender. But okay, upon knowledge that ecudaic is transgender, hmm, this particular Mr. Floresca, okay, had sexual intercourse with a transgender woman already, huh? Okay. Then, can that validation or can that sexual intercourse validate the voidable act? It can. It can be. Yes, because that is one part of what we call ratification or act of validating avoidable act. So if you discover fraud in your marriage, do not go to the honeymoon unless the discovery of the fraud happens during the honeymoon. So after the honeymoon, then you can now go to a lawyer for the action for annulment. Okay, do not have a live-in relationship already, or do not go to and have a live-in partnership already with that particular person when fraud is already discovered. Because upon the discovery of the fraud, you have 4 years to go to court to file the action for annulment. Otherwise, the action will prescribe. Okay. But if the discovery of the fraud happens before the honeymoon, and yet upon discovery and knowledge of the fraud, you still underwent honeymoon, then the honeymoon or the sexual act already ratified and cured the defect. That is the act of validating the voidable act. So it can be ratified. That is the meaning of that. No? It's so hard to explain this when you are not in that predicament, of course. Yes, it's very hard. You have to experience all of this defective contract in order that you can imbibe the meaning of all that I am talking about. Of course, this is only for theory purposes. But in the actual world, when you will be in business, you will encounter all of this defective contract. That's why I'm giving emphasis. No? But be that as it may, even though you have a working knowledge of all of these defective contracts, then you might still fall to be a victim. Okay, so if you're a victim, so you have to have the services of a lawyer. You cannot say, I can't do it by myself. I know the law. You cannot do that. As you were alleging yesterday in your CLD. No, even though you know the law, then if you become a victim, then you must need the services of a lawyer. You cannot just do things the way you like it. See how beauty the profession of a lawyer is, and it is very lucrative. Meaning, you might have a lot of money with this kind of profession. Yes. All you have to do is to know how to talk and talk about the law, and you know how to represent a client in court. That's now you go to cure. Time check 4:59. Cure. Now, is there a cure for void contract? None. Not even years. Okay. So, for instance, you were already living with your first cousin. You were married. You do not know that you were first cousin. You had been married for 50 years. Will that cure the defect that you had been married? Oh, that is already long time ago, so that is already accepted. Can you say that? No. A void marriage is a void marriage. It can never be cured by the lapse of time or by prescription. The same with what we call uh, unenforceable contract. Okay, years and years will not cure the defect. So there must be a remedy. You must remedy the defect. You must cure the defect. It's okay. Even if it is 10 years already, you can still cure it. Okay. But, okay, here for the resistible, it can be cured. Okay? Okay. But the curing must be within the passage of time. Like in action for rescission, only within 4 years. The same with annulment, only within 4 years. They may be cured by prescription. So be very careful. Now, so if you undergo what we call, or you experience a resistable or avoidable contract, you have to consult a lawyer and do that the soonest time possible. Because if you do not consult a lawyer the soonest time possible, your action or the cure may prescribe because it is cured only by the lapse of time. There's a limited time for you to cure the defect. After the limited time or the time has elapsed, then you cannot cure already the defect. Doesn't mean it cannot be remedied already. Doesn't mean if your time has expired. Okay. Now, when you go to court, who will go to court? Okay. And what kind of attack or what kind of case will be had? Okay. For a void contract, okay, of course, any of the contracting parties will go to court or anyone that is directly affected. Okay. Third parties can come in likewise, according to, like for instance, void marriages, first cousins. Okay. Who can go to court? Anyone of the husband and the wife that have been first cousins can go for the action for nullity. Or even the parents of the two of the couple who are first cousins can go to court upon discovery that they are first cousins. Suppose it is already 50 years that they discovered, can they still go to court for the action of nullity? Yes, because that is not cured by prescription. We have learned that, no? Okay. But with respect to unenforceable contract, okay, as a general rule, only that person, only by the contracting party, meaning only the persons involved in the contract can go. Like for instance, in an enforceable contract, like non-compliance with the statute of frauds. So who will go? Only those who are affected, the first party and the second party. Yeah. Okay. Those signatories only. So a third party cannot come in. But in some instances, according to law, then any third party or anyone who did not sign the contract can also go to court to attack the validity of the contract that is not in compliance with the statute of frauds. With respect to the seizable, okay, only the contracting party that is prejudiced, okay, that can file. Like for instance, in the guardian versus the ward, only the minor or the ward can go to court upon reaching the age of minority because he is the one who suffered the lesion or the damage. Okay. A third party can also come in if he is prejudiced or he also suffered lesion because of the rescisable contract. But with respect to voidable contract like voidable marriages, then only by the contracting party, with emphasis on the word only. Meaning it can only be the husband or the wife or the victim of the fraud that can go to court. The parent of the victim cannot go to court. Why? Because the law says so. You have to be very clear on that. So there are times that the mother-in-law or the parents of the couple will not be part of the case in court. Why? Because they are not the contracting parties. So if they will attack a void contract, what is the meaning of that? That is the only case that they will file, action for annulment or action for nullity. I'm sorry. Okay, that is the main cause or action. But it can also be attacked collaterally, meaning if there is a case, okay, if there is an existing case, another case, then they will allege that, Your Honor, can we also raise the issue that the two are first cousin and that their contract is the contract of marriage is null and void? Can it be accepted in court as a collateral attack? Then it can be. That is the meaning of that. But the main attack or the main action must be action for nullity. For what we call unenforceable contract, the same. No, it can be a direct attack on the unenforceability or a collateral attack, meaning side issues. There's a main contract, like contract for the collection of sum of money. Then they will allege that the contract is not in writing. Okay, so the main action is collection of sum of money, collection, no? But they can also attack, they say, it is not reduced in writing. Can they do that? Yes, that is what we call collateral attack. So it may be direct attack. The main issue there is the unenforceability because it is not reduced into writing and non-compliant with the statute of frauds, or, okay, it is only part of one of the issues in the case. Okay. With respect to the seizable on contract, the attack is only direct, meaning you cannot have a side issue. So if it is your case about action for rescission, then that is only the action. There's no other case. There's no other main cause of action. That is the only cause of action. You cannot have any issue or any, like for instance, you are suing another one for criminal case, and then you will say, Your Honor, can I also allege that there will be an action for decision because there's what we call lesion that had been suffered? You cannot do that. Okay. So the main cause of action will be simply for decision. For voidable contract, then you can have it direct also or collateral, just like with the void and unenforceable contract. Time check 5:07. So this is my comprehensive lecture series, Anel, the law on contract. Wow. Okay. So we still have time, 5:08. Okay. I will reserve the last interpretation of contracts and reformation of contracts uh, next week, no? That will be April 3. That will be my last lecture, and it will also be, no, it will be live. No, it will be live. May I request AQ that next week, April 3, you have to record the proceeding again, or the BDLEC, the last BDLEC, with respect to interpretation of contract and reformation of contract. It is very short for the benefit of my FS class. Why is it that more or less I am giving emphasis to the FS class with respect to the BDLEC? Because they are deficient in 2 day with 2 days. With the, I don't know, at the start of the final phase, we have done 2 no class days by virtue of the Panagbenga and the what's called EDSA revolution. See, that is 4 hours already. So if only they had that, then there is no deficiency in the beta legs as far as the FS is concerned. But because of that, then we have the deficiency. So I am trying to remedy the deficiency with my FS kit by virtue of what we call recorded beta legs. Okay, so Heikki said, okay po, Sergi. Okay, so that ends my lecture series, and then the law on obligations and the law on contracts, respectively. Although I still have 2 items, short items, reformation and interpretation, done the last day, okay, last day. And that will be April 3. And then also on April 3, considering that I will be absent April 4, then I will pronounce already my mi ultimo adios, my version of the CLB. It is very short, yes, but I have to do it very emotionally, okay, with full of emotion so that it can touch your lives. Okay, so done. So I will now pause with the recording. You can also stop the recording already.